All right, there's growing public outrage over proposed changes to South Africa's National Credit Act. The Department of Trade, Industry and Competition wants universities and colleges to be allowed to report unpaid student fees to credit bureaus. Critics are warning this could blacklist students and even trap them in debt before they even enter the job market. EFF youth leader and MP Sihle Lonzi has strongly condemned the proposal, calling it a cruel attack on young people's future and accusing the government of criminalizing student debt. The department, however, insists the backlash stems from a misinterpretation of the clause. Let's get a proper interpretation then. The department's spokesperson, Kaamil Alli, joins us now. Kaamil, thank you so much for joining us despite traveling at this point. Won't you just clear this up for us then? What is the current situation when it comes to student debt and tertiary institutions being allowed to use that and send it through to credit bureaus?
Well, thank you, and good morning to you, Arabil, and good morning to your viewers. I think the confusion came about as a result of perhaps from our side not particularly clarifying what exactly in the new draft regulations is being amended. What we see is the particular clause that's been generating some public outcry has been Regulation 18, subsection 7, subsection E. This is a regulation that has been gazetted in 2006. So the first thing to clarify is that there's nothing new with respect to student debt in the new draft regulations. What is new is a phrase that has been inserted, which reads to include juristic persons within the ambit of the regulations. And what this does is bring in small and medium enterprises, particularly sole proprietors, into the ambit of the national credit regulations, thereby allowing for finance institutions to access a history of small and medium enterprises and allowing them to offer them lines of credit. So they have no additional bearing on student debt as the current draft regulations.
So can you confirm for us that basically tertiary institutions will not be sending the credit records of students who have been indebted because of student debt to credit bureaus once they're done with their studies?
Not as a result of these amendments, Arabile. As it stands, the National Credit Act under Section 70 allows for institutions to enter into credit agreements with people. These are commonly referred to within universities as acknowledgements of debt. These acknowledgements of debt are sometimes sold by universities to debt collectors in order to regain the debt that has been incurred by students. But like I'm saying, this has been the case since 2006. So nothing new is being introduced as a result of these draft regulations.
Yeah, I mean, look, it's a growing student debt pile, plus you have, 17 billion rand in unpaid loans at this stage as well. What is the plan with regards to that, though, from the end of whether it be these regulations, understandings for SMEs, etc.? Is there kind of a conversation that you're part of that helps to clarify this?
You're referring to particularly the student debt problem,
correct,
if I understand your question correctly?
Yes.
Yes. So as a result of this, there has been some conversation that's been generated in the public and within government. The Department of Higher Education has reached out to us to have a conversation about it. Firstly, how it impacts on students, if at all, and then also to take the conversation further about how we address the student debt problem. But that conversation is at very early stages. We've really just touched base from I think yesterday it was. So a conversation has been started, and I think that it's an important conversation. I think that the problem of student debt is not something that the state can ignore, and it's something that we have to take forward, and make sure that we address in a sustainable way.
Let's talk specifically about DTIC, because I'm looking for clarification here then. How do we reconcile the stated intent to liberate SMMEs through credit access which is what you've made note of here by including juristic persons, with the simultaneous inclusion of educational institutions, which is the other part of this that people are arguing about, because some may say that this could actually entrench financial exclusion for economically vulnerable students.
Again, Arabile, I think it's important to separate the issues. The clause that refers to educational institutions has been there since 2006. So it's not something new that the DTIC is introducing. It's separate from the issue that we are trying to address, which is access to finance for SMMEs, which is what these draft regulations seek to do. We are closing the gap in access to finance for SMMEs. As you would understand, currently, SMMEs have to, unfortunately, access credit through the informal market, where credit lines are extremely expensive, interest rates are extremely high. So what we want to do is enable SMMEs to access formal financing institutions through these regulations, which will allow for them to access credit in the formal market, where there's a more standardized approach to the price of credit, the cost of credit rather, and the interest rates that are charged.
Yeah, I mean, one wonders then why the communication wasn't set up correctly here, Kaamil, because given the public outcry, there's at least 6,000 petition signatures. Does the department need to suspend or revise the draft to remove educational institutions, at least pending further conversation and investigations, or the right kind of communication first before putting this in play?
Well, I think we have to undertake a process, Arabile. It's not as simple as that, but we will definitely consider the comments that have been coming in from the public with regards to the student debt issue. It's not something that we intend to ignore. So we will consider it in the public participation process and come to a determination through the review process that needs to be undertaken once the public participation process has concluded.
Does that mean you've also considered alternative mechanisms in particularly building SMME credit histories, of course, because that's the key component that your department is speaking about, and it's the credit histories that do not involve expanding data collection to students?
Absolutely, we'll need to consider the various inputs that we've received from all stakeholders in this review process, and we'll have to craft it in a way that takes into consideration what we've received.
Just as I suppose here, because this kid's interesting when you talk about public submissions, which could overwhelmingly then vote to oppose the inclusion of educational institutions. And I know you've said that this is a part of this regulation 187E since 2006. But if there's this overwhelming opposition to this, will the department commit to removing the clause, or will there just be further consultations and conversations?
Yeah, that's a difficult one, Arabile, to answer at this point in time. We can't make a firm determination that the department will or will not withdraw any particular part of the regulations as they stand, particularly because these regulations are not the ones that are being amended. So we'll have to consider what it means, and we are in conversation with various sectors of society to try and understand what it means for the overall regulations.
Okay.
We don't want to take a decision that would inadvertently create problems within the sector that we're trying to address.
Yeah, and I can imagine the conversations here with tertiary education would need to be held as well. How much does this unlock, or how much would this have unlocked with regards to credit access for SMMEs, for example, just by including this phrase of including juristic persons?
Well, the analysis is still being modeled, Arabile, so the exact number is not yet available. But just to give you a sense, I think the reclassification of SMMEs, particularly as they refer to sole proprietors, creates an affordability assessment that is bespoke to these particular SMMEs and forgoes the sort of general assessment that other businesses are expected to undergo. There's also provisions around developmental categories, developmental credit categories, sorry. and classification of advancing this type of credit to SMMEs for developmental needs, for business development. And this is what we're trying to do to bring SMMEs into the remit of these regulations and the National Credit Act. So we're still doing the modeling and the analysis of what exactly that number would look like. But we hope to have those answers once we conclude the process in its entirety.
All right. Please share those with us, Kaamil, once you have them as well. Would be interesting to find out exactly. Thank you so much for the time, for helping with some sort of clarification as well, because it's going to have to be about communication on this one, ensuring that people understand where it goes to, who gets affected, and by how much. Kaamil Alli is the Department of Trade, Industry and Competition's spokesperson, speaking to us about these